Good afternoon, everyone. This will be a short update on another case in which an attorney used generative AI and failed to cite check the brief. The opinion we're going to discuss is Mid-Central Operating Engineers Health and Welfare Fund versus Hoosiervac LLC, number 2:24-CV-00326, pending in the United States District Court for the Southern District of Indiana, Terre Haute Division. Dated February 21, 2025. Mark J. Dinsmore, Magistrate Judge. Quote, on October 29, 2024, attorney filed a brief in support of defendant's motion to reconsider the court's denial of the motion to transfer. In that brief, the attorney cited In Re Cook County Treasurer 773 F 3rd 834, 7th Circuit 2014, a case the undersigned was unable to locate. In response to the undersigned's order to file notice with the correct citation, Mr. Ramirez filed a notice in which he stated that he was unable to locate the case, quote, acknowledged the referenced citation was an error and withdrew the previously cited authority and apologized to the court and opposing counsel for the confusion. On January 3, 2025, the parties in this matter appeared by counsel for a hearing on the order to show cause. The lawyer admitted he had relied on programs utilizing generative artificial intelligence to draft the briefs. He explained that he had used AI before to assist with legal matters such as drafting agreements and did not know that AI was capable of generating fictitious cases and citations. These hallucination cites, the attorney asserted, included text excerpts which appeared to be credible. As such, he did not conduct any further research, nor did he make any attempt to verify the existence of the generated citations. The attorney reported that he has since taken continuing legal education courses on the topic of AI use and continues to use AI products, which he has been assured will not produce hallucination cites. And I'm not going to name this lawyer. The lawyer agreed during the hearing that he did not fully comply with Rule 11, but he emphasized that at no point did he act in bad faith or proceed with malice. So, obviously it violates Rule 11 to cite non-existent cases, to not carefully think through what you're doing. When you sign that pleading, you're representing to the court that you wrote that pleading in an honest way, that to the best of your knowledge, information, and belief, the statements in there were formed after a reasonable inquiry to make sure that they were true. They're warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law for establishing new law. End result is the court sanctions the lawyer $5,000 per brief. So he filed 3 different briefs with AI citations. The undersigned recommends that the attorney be sanctioned $15,000 for his violations in the case, $5,000 for each of the 3 briefs filed, where he failed to appropriately verify the validity and accuracy of the case law he cited to the court and opposing counsel. Ouch. The only thing you can say is you got to be really careful using these products. Don't trust them. Don't think that you're going to be able to fake it. Instead, get more time to do the brief if you're rushing. The magistrate also found that the lawyer may have violated 3 rules of professional conduct. Rule 1.1, competence. Obviously, submitting fake citations is not competent. Rule 3.1, meritorious claims and contention. Quote, there is no merit in relying on non-existent cases. So the conduct disregarded the rule. And then 3.3, candor toward the tribunal. Quote, a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Indiana Rule of Professional Conduct 3.3A1. It is undisputed that the attorney made false statements of law to the court when in 3 separate submissions he relied on at least 3 cases which do not exist. And then the more important finding, moreover, The attorney did so knowingly. He knowingly failed to fulfill his duty of verifying that the law he presented was good law. As such, the undersigned believes that discipline for violation of Indiana Rule of Professional Conduct 3.3 is appropriate. The end result is a sanction. The lawyer is sanctioned $15,000, and the matter is also referred to the chief judge for discipline. Discipline is going to be virtually guaranteed. Shouldn't be more than a reprimand because the lawyer has already, frankly, been disciplined quite a bit. This is an unfortunate situation. You just have to be very careful when you're doing this, that you don't make this mistake. Just check the cases you're citing. Check everything. And even if the AI program you have used says it doesn't make stuff up, don't believe it. Check it again. As a young lawyer, I learned to check cites of briefs. It's often done. It's something that everyone should be able to do. You can use Google to do it. There's Westlaw, Lexis, and the old Shepherd service, which was done by books. Again, let's be careful out there. Let's stay out of sanctions and stay out of trouble. Thank you.